Good evening, friends. I have been invited by GSTandAgri.com to share my views on the landmark judgment by the Honorable Delhi High Court in case of Loreal India Pvt Limited versus Union of India, writ petition number 12557 of 2022. Friends, it is actually a landmark decision for all the FMCG companies who are supplying goods to the consumers. The question is very interesting. As for the facts, L'Oreal has been supplying the consumer goods, particularly the cosmetics and other goods. It was supplying those goods at a particular grammage and at a particular price. Now the GST rate was reduced and it was supposed to pass the benefit of the reduced rate of GST to the consumer by reducing the price of the product. But rather than reducing the price of the product, the company increased the grammage. So suppose earlier it was supplying for 100 grams for 100 rupees and there is a reduction of GST rate by, let's say, 10%. So it was supposed to reduce, let us say, the price by 3 rupees. But in instead of reducing the price, it increased the grammage, meaning thereby for the same 100 rupees, it is now giving 105 grams in the bottle of cosmetic or the tube of cosmetic or the product which it is supplying. Now, National Anti-Profiteering Authority, the case was taken up. The first question which was taken up, can National Anti-Profiteering Authority take up a matter suo motu, meaning thereby when it is not the recipient of the goods, can the matter be taken up by the NAA suo motu or by any person who is not the recipient of the goods? The Honorable Delhi High Court, referring to the decision in the case of Patanjali Ayurveda Limited versus Union of India and others, writ petition number 4375 of 2020, it clarified and it rather reassured that the issue of suo motu power of National Anti-Profiteering Authority to take up the issue against any company is settled. And in this particular case, Patanjali was directed to deposit the entire profiteered sum. So the first issue, that whether it can be taken up, it is settled. Second issue which came up, that the benefit has gone to the consumer. Now it has not gone in the form of reduction of the prices, but in form of the grammage, which has been increased in the product quantity. So can we say that the benefit which the company was supposed to pass has been passed? Now on this particular aspect, the court was very particular, and in para 18 it observed that when a statute clearly provides in a manner in which something has to be done, and the duty is casted on the supplier to extend the benefit of rate reduction by reduction in prices, the supplier cannot insist that instead of reducing price, he will give extra grammage to the consumer. So the Honorable Delhi High Court has made it very clear that when the Act is very, very clear in providing that the benefit, how it has to go to the consumer, it has to go in the manner of reduction of prices. So there is no choice with the company that in alternate it can give the benefit to the consumer by any other mode. So any other mode in this particular case was by increasing the quantity. It can be providing 1+1, or for that matter, any other product being given together with this particular product. All these kinds of benefits will not be taken into account for the purpose of 171. The Honorable Delhi High Court again, on the arguments which was taken up by the department, which they said that collection of taxes is not the only goal of this particular act. It was also the provision section 171 was talking about reduction in prices so that the cash in the hands of the consumer can increase. That is because he's now paying less for the same product. Even though you are trying to benefit the consumer, but you're not giving the exact benefit which the act was asked the supplier to provide to the consumer. So that is where the section was very, very particular, and it never left a choice with the supplier that you can extend this particular benefit in any other manner. It was only by way of reduction in prices of that particular commodity or product or goods. Now, there are other takeaways also, but my dear friends, I would highlight one very important observation of the Honorable High Court. The Honorable High Court was very sensitive to the very fact that 171 is not a charging or taxing provision, it is an incidental provision. And when it is an incidental provision, it will support the act, not in terms of taxing or charging or creating a charge on the supplier, but it was trying to achieve an objective of eliminating the cascading effect of taxation for the consumer and to pass the benefit of the rate reduction to the consumer, to the ultimate consumer. So the benefit which was there was for the consumer welfare. So it is more of a consumer welfare provision rather than a taxing provision. And it should not be seen in that particular spirit. So when you're reading 171, be very, very specific. 171 is not one section which gives a very wide kind of choice to the supplier. While when we read this particular decision, we definitely understand that the focal point of this particular dispute was, can the benefit be given in any other manner other than by reduction of the prices? The answer is no. But there are other important aspects, and therefore this particular case, while this aspect has been decided, this particular case has gone into the larger batch of cases which will be heard against the decisions of National Anti-Profiteering Authority and which will be taken up by Honorable Delhi High Court as a batch of matters. So let us wait and see. There are many other aspects which will come before us once that particular batch has been decided. Thank you. Thank you, friends.